Well, good afternoon, Michiganders. It is Tuesday, January 17, 2023. And this is, of course, Tuesday with Tom, Michigan's only weekly podcast where we do answer your questions about estate planning and estate settlement in Michigan. And we don't send you a bill. As always, I'm your host, Tom Doyle, estate planning attorney, lifelong Michigan resident, and ambassador for all things good in this great state of Michigan. Welcome to today's program. With just a brief recap, last week's episode, do you know what your estate plan must include? Many of you made New Year's resolutions. One of those resolutions might be to get your estate plan in order. So it's important that you know what your estate plan must include. So if you're looking at that, I invite you certainly listen to last week's episode. Today's episode, though, a question that Amanda and I get all the time, not just from clients, but even financial planners who are fairly knowledgeable about estate planning as part of their background, etc. But it's a very common question that we get, and that is, does a pour-over will avoid probate? But please remember, as always, what I'm about to discuss during the program is for educational purposes only. It is not intended to be legal advice. You need to work with your attorney to determine what is appropriate for you and your estate plan. Does a pour-over will avoid probate? Well, let's start with what a pour-over will actually is. And we're going to take a step back, and we're going to assume that you have a living trust as part of your estate plan. And I tell clients all the time, think of it as a living trust as though you're building a box, and the box is your trust. And the box is going to hold assets that you own. And the box is going to have instructions on it as to how those assets are going to be distributed at the time of your death. Well, the first question we are always asked is, well, if I have the trust, do I need a will? And that will, the answer to that is yes, you do. And the will is sometimes referred to as a pour-over will, meaning it moves assets into your trust. Think of it as it pours assets over into your trust. And the reason for having the pour-over will is you want to make sure that all of the assets are in your trust so that they're all distributed the same. And let me just give you an example. Let's say that you're a single person and you have a house. And maybe your estate plan is that upon your death, you want your estate to go to maybe one of your children. And let's say you have more than one child. Well, the trust that you have created for you will have distribution language in it. And that distribution language is going to talk about where your estate's going to go at the time of your death. And it would likely then say that either your house in particular, or perhaps other assets even beyond your house, go to one child rather than to all of your children. The problem, though, is that if you do not put your house into your trust, it is not going to be controlled by your trust. So if you never have a deed prepared for your house and you simply keep it in your name and you die, now what's going to happen? Well, if you don't have a will, intestate succession is going to determine where that house is going to go. And in our example, intestate succession is going to have that house going to all of your children, where your estate plan actually only had the house going to one of your children. So the house needs to go into the trust so that it will be controlled by the trust, so it will be distributed per the terms of your trust. So in that case, not having the home in the trust, not having a pour-over will would result in the home not going where you wanted it to go in your plan of distribution. Another example, very common, minor children. Many clients are going to say, I have minor children. I don't want my children to inherit the estate when they turn 18. Or maybe we're dealing with grandchildren. We don't want grandchildren to receive the estate when we're 18. Well, another example, let's say I have a bank account in my name and I don't put it in my trust during my lifetime, and now I die. If I don't have a pour-over will, that bank account is now going to go where the state of Michigan says that bank account should go, under what we call intestate succession. And under intestate succession, if it's going to children, the state of Michigan doesn't care what the age of the children are. It's going to allow them to have that bank account when they turn 18. That's not what you wanted. You wanted it to be held beyond age 18. Perhaps you want it to be used to go to college, etc. Again, an example of where you need to make sure that you have that pour-over will, so that bank account that was not put into your trust during your lifetime, it was not funded to your trust, is the terms that we use as lawyers, will at least end up in your trust, will end up in the box with the other assets that you have, and now it will be controlled by the terms of the trust. And in that example, it will be managed for the child, children, grandchildren beyond the age of 18. So the point, again, of the pour-over will is to make sure that everything is inside that box, and so that everything gets controlled by the terms of the trust. But, and here's the big issue, the pour-over will does not avoid probate. Let's talk about how it works. Essentially, a will, whether it's a pour-over will or not, any will that you have is a meaningless document until three things have happened. One, you have died. Two, a probate estate is opened. And three, that will is admitted to probate. Again, you have to die, a probate estate has to be opened, and that will has to be admitted to probate, which means what? That will doesn't avoid probate. That pour-over will doesn't avoid probate. Essentially, what that pour-over will does is it says, hey, when probate is finished, take the assets that had to go through probate and put them into my trust, for, in that example of the house. If you didn't put the house into the trust during your lifetime, what that pour-over will is essentially saying, when the house goes through probate, when probate is finished, take that house and now put it into my box. Or the bank account example. I didn't put the bank account in my trust during my lifetime. When probate is done, take that bank account and add it to my box. So it pours it over into the trust, but it only pours it over once your estate goes through probate. So the purpose of the will, the pour-over will, is to be sure that if you failed to fund assets to your trust during your lifetime, they will go into your trust after you die. Think of a baseball. You've got the pitcher and you've got the catcher, and what's normally behind the catcher is the backstop. Now, why do they have a backstop? Well, the idea is the pitcher throws a pitch, and the catcher should catch all the pitches unless it gets hit by a batter. But assuming it doesn't get hit by a batter, the catcher's supposed to catch all the pitches. Well, what if a catcher misses it? What if the pitcher throws it wide, or the catcher fumbles the pitch? Now you've got a backstop that keeps the ball from going into the stands. Similarly, I suggest you think of a pour-over will. It's there as a backstop. We hope that during your lifetime, you have appropriately funded all of your assets into your trust. You've done everything that you needed to do. You've had appropriate deeds prepared. Maybe you've had beneficiary designations put on your bank accounts, whatever it happens to be, that you've taken all of your assets and you have appropriately put them into your trust during your lifetime. But if you didn't, let's say you forgot something, and we see that all the time. Somebody forgot an asset. We never even knew that they had it. They never even told us that they had it. They forgot about it. Now that asset, the pitcher's pitching, the catcher's missing, but we don't want it to go into the stands because we don't know where it's going to go. We have a backstop, which is, in that case, the pour-over will. At the end, it's really a document that we hope never gets used. We hope that the will, pour-over will, never has to be used for anything. But it's important in case something does have to go through probate, so that you can be assured that your entire estate is going to be distributed per, if you will, the terms of your trust. So don't plan on using your pour-over will as a trust funding tool if your goal is to avoid probate. If your goal is to avoid probate, the plan is to have everything appropriately designated into that trust during your lifetime, so that upon your death, nothing has to go through probate. So don't rely upon it to fund your trust if, in fact, your goal is to avoid going through probate. Of course, as always, Amanda and I would be honored to have the opportunity to help you protect your loved ones by putting together your estate plan, amending a current plan, or assisting you in settling your estate, or looking at the funding that's occurred in your estate plan, making recommendations. We can actually put together what we call a trust funding plan, where we're going to list all the assets and make recommendations for what should be done to put those assets into your trust. And all you have to do is head on over to our website, doylelawpc.com. There you're going to find out how it is that you can schedule in-person consultation with us in our East Lansing office, or how you can schedule virtual consultation, be it via Zoom or telephone. All that information is available at doylelawpc.com. And again, if all you're looking for is one document, maybe all you need is a new healthcare power of attorney, or you need a new certificate of trust, check out our legal store that's at doylelawpc.com, where you can order documents online, submit information to us, make payment online, and then we can prepare documents and even email them to you for you to print and have them executed at your end. Again, visit doylelawpc.com for all of that information and to schedule your consultation with Amanda or myself. Well, kind of a short program today, but that's okay. Sometimes some programs are shorter than others, but as always, if you have a question or a comment about the program, a topic that you'd like to have me discuss, or questions that you'd like to have answered, please send me an email, tom@tuesdaywithtom.com, or you can always drop a postcard in the mail to me as well, but certainly email is going to be quicker. Again, that would be tom@tuesdaywithtom. tuesdaywithtom.com. Always, we invite you to follow us on Facebook, follow us on, well, we're not using Twitter anymore, so I almost said follow us on Twitter, but please follow us on Facebook, and have your family and friends follow us on Facebook as well, and that will be at Tuesday with Tom, or the law office, which is Doyle Law PC. Remember, too, that the program is available probably anywhere that you want to listen to a podcast. Certainly program services like Apple Podcast or Spotify or Google Podcast, iHeartRadio, Spreaker, etc. There are too many different podcasting channels for me to name them all during the program. So whatever podcasting service you use, do a search, and you will likely find Tuesday with Tom is going to be available there. And if you have a smart speaker at home, you can always ask your smart speaker to play Tuesday with Tom as well. Well, thank you again for spending some of your time with us today. And as always, I hope that you have an awesome day and an awesome week in Michigan. Stay safe. Tuesday with Tom has been brought to you by the estate planning attorneys at Doyle Law PC. To learn how we can help you with your estate plan or with settling a loved one's estate, please call us today at 517-323-7366. That's 517-323-7366.